In Trump v. CASA, the Birthright citizenship case the Supreme Court heard about 10 days ago, the nationwide injunction solution was thrown out. However, the majority opinion in that case said that if you could put together a certifiable class action, it might be a solution to the issue. So today in New Hampshire, a judge has certified a class action where the class is made up of babies born after February 10, 2025. Not the parents, not the families, but the babies themselves. So undoubtedly, this will go to Supreme Court review. So since we don't deal with the Federal Rules of Civil Procedure 25 on class action every day, let's review what will be involved in the discussion, review, and decision. Under Federal Rule of Civil Procedure 23, any case seeking class certification must meet specific legal standards. That's one of the things the Supreme Court liked about class actions in Trump v. CASA, is there was already a specific rule. They could follow it. They could come up with standards. So let's walk through what those standards are, starting with the 4 threshold requirements of Rule 23A. First, numerosity. The class must be so large that joining all the individual plaintiffs would be impracticable. While there's no exact number, federal courts generally find that 40 or more plaintiffs meet this requirement. Second, commonality. There must be at least one question of law or fact that is common to all members of the class. This doesn't mean every issue must be shared, just that a single legal or factual question ties the claims together. It'll be interesting to see how they constructed the class to meet this requirement. The Supreme Court emphasized this in the 2011 case of Walmart v. Dukes, clarifying that common questions must be capable of generating common answers that drive resolution of the case. Third, typically the claims in the class represented must be typical of the claims of the class as a whole. In other words, the lead plaintiff's legal issues and injuries must mirror those of the group they seek to represent. So all these babies are going to have the same situation in order to be classed together. Fourth, adequacy. The class representative must fairly and adequately protect the interests of the class. This includes not only the plaintiff, but also their attorney. I'm not sure how the babies, without their families, will meet this standard. The court will examine whether the legal team is competent and free of conflicts of interest. The American Civil Liberties Union lawyer group is the attorney for the class. Once these 4 prerequisites have been met, the class must also fit into one of 3 categories under Rule 23B. The first category, Rule 23B1, is for classes where individual lawsuits would create a risk of inconsistent results or impair the rights of other class members. These are often used in pension or trust fund cases. This won't apply. We don't have a limited number of citizenships. We have an undeterminable number of citizenships. One baby getting a citizenship will not deter another baby from getting a citizenship. In fact, some could argue that this whole classification is silly. That's the legal word, silly, because I cannot imagine the Supreme Court ruling that some babies will become citizens while other babies won't become citizens merely because some of them had an injunction. I just don't see that happening, but let's move forward. The second category, Rule 23b-2, applies when the defendant has acted or refused to act in a way that affects the entire class. An injunctive or declaratory relief is appropriate. So if you say that the federal government is going to require injunctive relief in order to stop this action, this might be the route. This type of class action is common in civil rights litigation where uniform policy or practice is challenged. But once again, it's how the class is constructed. The third and most common category is Rule 23b-3. Here the court must find that common questions of law or fact predominate over individual ones, and that a class action is the superior method for resolving the dispute. This category is typically used in consumer product liability, and securities fraud cases. If the class is certified under Rule 23b-3, the court must also ensure that class members receive notice and an opportunity to opt out. It is possible that there may be babies within the class who wish to opt out. How you notify these babies that they can opt out, I'm not sure yet, but we'll see as time goes by. The court must also ensure that class members receive notice of an opportunity to opt out. In addition, these rules, some federal courts require that the class be ascertainable, meaning the class must be defined in objective terms and it must be feasible to determine who belongs in the class. Well, you're going to need some peripheral information to know. I mean, basically, to know you are in this class, we'd have to go look at the standards that are set by the Trump executive order and then check on the parentage of each one of these child to know whether they fit. Finally, the court must appoint qualified class counsel under Rule 23G. As I said, the American Civil Liberties Union attorneys will be representing. Attorneys must show they have the experience, resources, and commitment to effectively represent the class throughout the litigation. The American Civil Liberties Union is an excellent choice for this. To summarize, a class must meet the 4 Rule 23A requirements: numerosity, commonality, typicality, and adequacy. Then it must qualify under at least one of the 3 23B categories. And the court must ensure the class is clearly defined, properly notified, and represented by competent counsel. This process is designed to ensure fairness and efficiency, allowing similar claims to be resolved together while protecting the rights of those involved. So we'll be following up on this to check out this class and see if we can figure out how it all fits together. You have a great evening. Come on back and see us.